Hey everybody, criminal defense attorney Ryan Pacyga coming at you. I'm from Minneapolis, Minnesota. My office is right across the street from the courthouse. After the announcement of the verdict, I did a couple quick news interviews and then I got out of downtown, as a lot of people got out of downtown. Some people did congregate around the Hennepin County Government Center where the trial occurred, waiting for the verdict. Others were down at 38th in Chicago, the scene of the George Floyd killing. And now I'm coming at you after having just watched the verdict. Derek Chauvin found guilty by the verdict unanimously, 12-0 on all three charges against him, which were second-degree unintentional murder, third-degree manslaughter, and third-degree murder and second-degree manslaughter as well. So now what happens? Here's why I'm making this video. I thought I'd educate you about this process. So the state had made a motion earlier that if Chauvin was found guilty of any of the charges, they were going to seek what's called aggravating factors. The reason that they do that is Minnesota uses what's called a sentencing guidelines grid. All right. Think of it as a grid with a vertical axis and a horizontal axis. And within these axes, you match up the severity of the crime on the vertical axis and someone's criminal history on the horizontal axis. And you get to a box. All right. And so the top count in this case, second-degree unintentional murder, carries a presumptive prison sentence of 150 months, all right? 150 months. And here in Minnesota, you serve 2/3 of your time in prison unless you have bad behavior as well. But you get basically a third off for good behavior. So that would be 100 months, for example, on the second-degree murder charge. If the judge sentences Chauvin under the sentencing guidelines, presumptive matter. But because the state filed a motion for aggravating factors, now the judge is giving the defense had two choices. They could have left this decision about whether there were aggravating factors to the jury, such as, was the crime committed in the presence of a minor? Did the defendant act with particular cruelty during this crime, or things like that? Those are aggravating factors. If the jury or the judge were to find aggravating factors, the judge can depart, which means go beyond what the recommended sentencing guidelines are and go above those for an upward departure. The judge is not required to go above, but it gives the judge permission to, if aggravating factors are found. The defense had already waived the defendant's right to have the jury decide if they were aggravating factors. So now that is alone in the judge's hands. So the judge today, after the announcement of the guilty verdicts, the judge has given the defense 1 week to write a brief, which is a written argument to the judge about why or why not these aggravating factors should be applied, and if the judge, and why in the defense's mind the judge should not depart above the guidelines, or why these aggravating factors were not present. The prosecution can certainly file a brief opposing that as well. So that's number one. That's due in 1 week from today, so April 27th. All right. The next thing that's going to be happening is that every defendant, if they're found guilty or plead guilty in a felony in Minnesota, has to go through what's called a pre-sentence investigation. What that is a whole background study about the defendant, from their education, all of their jobs that they've had, chemical dependency issues, mental health issues, family life, criminal record or lack thereof, sometimes their faith, their social activities or lack thereof, and a whole bunch of other things, their version of the events, their attitude of it, the impact on the victim, and all those sorts of things. And this is a packet that's done by probation, and it includes the defendant filling out intake packets, as well as having an interview with a probation officer about their version of the events and their feelings about it, and whether they're amenable to probation and all those sorts of things. And the purpose of these pre-sentence investigations is a few things. One, they don't want to miss any prior criminal history, so that if things are enhanceable, like if you've got a prior DWI and now you've got a second one, there's mandatory minimum sentences that come in. They don't want to miss those. Or if you've been prohibited from possessing a gun in the past and you got in trouble here, they don't want to miss those things. Were you on probation for anything else at the time, right? So that's one thing. They don't want to get the criminal history wrong, because the larger the criminal history somebody has, the longer their sentence is going to be. Second, it gives the judge an idea, most importantly, of who they're sentencing. What was their role in the crime? They've seen a trial here, so the judge can figure that out. But what kind of person is it? If they had any difficulties in life that the judge should consider, such as mental health things or other things like that, or is there the absence of that? What kind of life have they led other than this sort of case? So the judge has a better idea than, rather than your defendant, this is your name, I've seen you in a trial, and that's all I know about you before I sentence you. That's not a good idea. It is a good idea for judges to know more about the person they're sentencing so they can make these difficult decisions sometimes about what kind of sentence a person should get. Should there be an upward departure? Should there be a downward departure in those things? So the judge will learn a lot more about Mr. Chavin after having read a pre-sentence investigation packet. That packet will come, usually that's very standard in Hennepin County, 6 to 8 weeks after the guilty plea, or in this case, the guilty verdict. And then the lawyer will be able to use that packet, both sides, to argue, to use information to argue for a lower sentence than the guidelines call for, or an upward departure, or what's called a guideline sentence. And then finally, we have the sentencing hearing itself. And I think Judge Cahill said that'll be about 10 weeks from now. So what'll happen is the judge took Chavin into custody. The defense lawyer didn't even oppose that motion that the state had. You can bring a motion or have a motion to keep your client out of custody, a defendant, if they're found guilty. But this is a presumptive prison case. And it's uncommon for a defendant to be able to stay out of custody following a guilty verdict in a felony trial. It's not completely unheard of, but the defense lawyer didn't even ask for that anyway. So his client's in prison or in custody in the jail immediately, and will be going through that interview process while he's at the jail as opposed to staying out. And then the sentencing hearing will take place in about 10 weeks. And what we're going to have there is, yeah, you can anticipate there's probably going to be arguments from the defense for what's called a downward departure, which means, judge, give them a sentence that's lower than what the sentencing guidelines called for. And the defense will try to cite factors about why that should happen. The prosecution will be asking for a sentence that's higher than what the sentencing guidelines call for. And the judge will have to decide, do I give Chavin a guideline sentence, which is where the judges are presumed to begin? Does the judge have the ability to depart upward because of aggravating factors? And if so, does the judge determine that just because he can, he should? He may say, I can, but I'm not going to. He may say that I am going to. We just don't know those things. Or does the judge find a reason to depart lower than what the guidelines call for? I don't expect that in this particular case. I just don't see that happening, but you never know. The judge is the judge, and that'll be up to him after he considers the arguments of the defense counsel and the prosecution. So for now, Chavin will stay in the Hennepin County jail. He won't be transported to a prison right away unless they put him somewhere else for his safety. They might keep him out of the Hennepin County jail and keep him in solitary somewhere for his own safety, as they had done earlier in this case when he was arrested. They may do that. They may put him on a suicide watch. I'm not saying he said anything about that, but sometimes in situations, if they think there's some emotional factors present, sometimes they'll put someone on a suicide watch for a little bit. Again, I'm not saying that will happen, but it's possible. So that's just the basic process. And I just wanted to educate people about that and kind of where that's going. Eventually now, the defense will have plenty to appeal if they choose to appeal. There won't be any appeals between now and the time of sentencing. But after the sentencing, the defense can do post-conviction sentencing and the like. And the defense may also try to investigate whether there was anything allegedly improper with the jury, such as jurors doing their own research, or juries talking to people about the case that they shouldn't be, or jurors being intimidated by outside forces or whatever. I'm not saying that was or wasn't there, but you could expect the defense to be looking into all of those things, as they certainly did have some concerns about pretrial publicity and pressure on jurors and those things. Again, I'm not saying that's a good or bad thing. I'm just telling you that those things may begin to happen. Chavin would have plenty of time to appeal after he's sentenced. And then if that happens, of course, we'll see what happens with a number of things in the case, but that's for another conversation. Just wanted to educate the public. I'm criminal defense attorney Ryan Pacyga. You can find me at arrestedmn, like Minnesota.com. That's arrestedmn.com. Please be safe tonight. Be good. Let's find a way to come together. This part of the trial is over. God bless Minneapolis.